SJC-12388, Commonwealth v. GF.
Morning, Your Honors. Justice Gantz.
Mr. Keeling, 1 second, 1 second. Can't hear you until the clock starts.
Thank you, Your Honor.
Okay, now you can start.
May it please the Court, Your Honors, my name is Joseph Piniele. It's my privilege to recognize my colleague, Attorney Michael Farrington, as representing the defendant in this appeal. He will be referred to throughout this as the defendant. Now, Your Honors, I think that to start with, I think there are a couple of overriding considerations this Court should keep in mind when reviewing the many issues in this case. The first is that, in fact, this is not a criminal case. This is a mental health proceeding. The second is a mental health proceeding that, in fact, involves potentially the massive curtailment of an individual's liberty. And as a result of those 2 points, Your Honors, I would submit that in crafting this legislation in this case, the legislature, in crafting the civil commitment statute, the legislature intended for these trials to move quickly. In this case, Your Honors, it's been 6 years, 9 months.
Counsel, I know you want us to keep those things in mind, but to what extent do we consider the responsibility your client bears and how long it took for this case to come to trials?
Well,
he did ask for his own continuances a lot and waive a lot of time considerations.
he asked.
So we can't really say all that time, right? How much would you say realistically?
Is the responsibility of the client?
It's not the responsibility of your client.
Well, I would suggest here that on June 11th, or June 1st of 2011, the defendant moved for a motion to dismiss for violating 14A. That was filed. As of August of 2011 was the last action that the Commonwealth took on this case for 11 months. They did not move to do anything in this case from August 2011 until July 30th of 2012. At that point, they moved for trial. It took them 2 months after that, in fact, to then move to have the qualified examiners updated, the reports updated. Those reports did not come for another 2 months. Now, this is 559 days of no action in this court. And during the course of this time, the defendant was not sitting on his hands. He was not just simply acquiescing to this. He had filed a motion to dismiss this case for violation of 14A. And in fact, that was denied. After the first trial ended in a deadlocked jury, the Commonwealth waited for 2 months, more than 2 months, to request updated qualified examiner reports. Those qualified examiners reports, which under 13A are supposed to come within 45 days, they did not arrive for 8 more months. Now, this court said in Commonwealth versus Ganji that it is the responsibility of the Commonwealth to ensure the qualified examiners reports are filed in a timely manner. So there's another 10 months that would be applied. After the second trial, there was a delay because counsel for the defendant fell ill. But after that, there was another request for qualified examiner reports, which did not come for another 2 months.
Before we get through the 5 years
Certainly.
period, the statute requires a trial in 90 days, right?
60.
I'm sorry, 60 days. And if not, the case is dismissed.
I think that the 60-day,
With Rule 36 exclusions.
the 60-day rule applies in almost 2 parts. There's the point when probable cause is found until the time that the case is called for trial. And then there's another 60 days that would be allowed afterwards from the time that the case is called to trial until the trial commences. And at that point, Your Honors, there is a little bit of wiggle room in terms of whether there's a good cause provision in Section 14A that allows for good cause for a delay. However, as Justice Wilkins said in his lower court decision, the legislature clearly contemplated that the delay here should be something that would be counted in months, not years, in this case, more than a half a decade. I would submit that in addition to the 2 years that I've already suggested, there's 151 days that the Commonwealth pursued its single justice appeal of Judge Wilkins' determination that an asymmetrical jury verdict would be given. That was a case that was brought to the single justice of the appeals court. It was bounced back and filed without prejudice, and then refiled again by the Commonwealth.
So if a judge makes a decision that the Commonwealth believes is clearly wrong, the Commonwealth shouldn't be able to take
They
that
absolutely should
interlocutory
have the
appeal?
right to appeal that. The point is, Your Honor, that it's not, that time is not on the defendant. The defendant does not have to concede and give up that right that was granted him by the trial judge in order for the case to be expedited.
But don't we just take our Rule 36 jurisprudence and craft it onto this?
There's been suggestion that's been the case, but I mean, if we're talking about Rule 36, Rule 36 involves a year. And I submit that if you look at all the delays,
No,
including...
I meant the good cause components of Rule 36, what's excludable, what isn't.
Yes, but I think that to some extent, the notion that this is lined up correctly, perfectly with Rule 36 is a bit difficult because this is not a criminal trial. In a Rule 36 case, if there's a violation if there's a delay, the defendant might get some benefits from that. He might be able to extract some concessions. He can get time served for the time that he spent.
Your client asked for the delays, many of them, to benefit himself.
He did ask for some of the delays, Your Honors, but he didn't ask for all of them. And there were years that went by, including, like I said, this period from August of 2011 until December of 2012, when he had moved to dismiss his case and no action was taken by the Commonwealth to move the case forward. And the other thing that needs to be kept in mind is this whole notion of that a retrial is permissible after a hung jury is found. There's nothing in the statute, as we've noted, to indicate that the legislature intended that to be the case.
Well, now, though, but don't we import criminal right protections into the SDP statute?
Well, generally, those protections that are important to the SDP statute are to protect the individual liberty of the defendant.
So public safety and other considerations don't factor
Well, I
into
mean,
this?
I think you would look to this court's case in Commonwealth versus Knapp, where they said that in crafting the 120-day time period to bring this case to trial, the court was striking that balance between protecting the public and protecting the individual liberty of the defendant. Now, in Pariseau, this court said that once the delay starts becoming beyond 120 days, then the balance becomes upset. This is 6 years, 9 months, and 1 day. I would suggest that this delay is far beyond anything that either the legislature or Pariseau had contemplated. So absolutely, there's a responsibility to protect the public, but at some point, a pursuit becomes beyond the bounds of reason and justice, and this court has to act in those circumstances.
What, and there may not be an apparent answer to this at this point, what role or consideration or weight should we give that question that the juror put to the judge, or the statement the juror made in a note regarding you're referring to him as the defendant, the petitioner's non-cooperation with the qualified medical examiner?
Well, one thing that the juror did not know, I believe, is that the petitioner had in fact been interviewed by qualified examiners on 4 different occasions prior to him deciding not to do it anymore. And to answer your question more directly, Justice Seifer, I would suggest that this is a juror whose knowledge of the civil commitment statute is limited, one would think, to the instructions by the judge during the course of this trial. I do not imagine that his understanding of the trial process is much more extensive than that. And so I would caution this court, when giving a great deal of weight to an aside by a juror who had already been part of a case. I don't think you should take that for a significant amount of a significant authority at all.
If I can turn you back to Pariseau.
Sure.
Pariseau says, first trial of the defendant, and the judge takes an inordinately long time to decide the case. And the court looks at what a remedy might be and says that one of the remedy may be, while we're waiting for the judge to decide, that the judge could put the individual on supervised release. Would that be an appropriate remedy here, that given the delays, the judge would have the authority to put the person on supervised release, which we've said the judge can do in Parizeau.
That's possible, but I would submit, Your Honor, respectfully, that that does not go far enough. I don't believe that 14D contemplates a retrial. The plain language of the statute premises further commitment.
Suppose you lose on that one.
Pardon me?
Suppose you lose that argument. Can you answer his question?
If in fact that he's not released, I would think that if he's not released on that, I would also submit that due process would, the violation based on the delay here would. But yes, I mean, I think that if in fact there was no other alternative but to stay committed and let these retrials persist into apparent perpetuity, then some sort of relief should be given to the defendant.
Let's go back to 14D. I mean, I haven't been doing this for 20 years, and I still learn stuff when I read more closely. So 14D says, quote, if after the trial the jury finds unanimously and beyond a reasonable doubt that the person named in the petition is a sexually dangerous person, such person shall be committed to the treatment center. It is silent as to what should happen if the jury finds unanimously that the person is not SDP. But I think we infer, or it's implied, that if the jury were to find that, although the statute doesn't say so, we understand the person must be discharged, correct? So we sort of are implying that, even though the statute doesn't state it.
Well, I think, Your Honor, that every time things are implied in the absence of language from the statute, then you're departing from your long-held sort of determination. This court does not read into a statute a provision that the legislature didn't see fit to put in there.
Well, I mean, I assume you are not
It's not
suggesting that
necessarily
when
a
the
good
jury
argument.
unanimously finds the person is not SDP, that the person should not be discharged. So
No,
don't-
right, no, my
so
point,
we need to imply that.
Maybe I misunderstood the question.
I think you probably did. But
I apologize for
the
that.
point is that discharge after a unanimous finding is essentially implied, not stated. There's no sentence after that which says, where a jury finds unanimously that the person is not SDP, that person shall be discharged.
Exactly.
It's not there.
No,
But,
and you know,
we imply it.
if we were going to, if the legislature saw fit, they could have just injected the first 5 words of Rule 27 from the Rules of Criminal Procedure. The verdict shall be unanimous. They could have put that language in there. It's not in there. And in fact, in a larger sense, this court in the Sheridan case in 1996 said that the criminal rules do not apply. The statute states that if after a trial, the jury does not find the defendant to be, unanimously does not find the defendant to be sexually dangerous, he should be released. The statute says that the only basis for continuing commitment is a unanimous finding that the defendant is sexually dangerous. That's it. It doesn't allow for any alternatives.
You're asking us, I mean, we have to imply something. So you're asking us to imply that where there is no unanimous finding, the defendant shall be discharged, or the person shall be discharged.
I'm not sure if that's an implication other than just a plain reading of the sentence here, Your Honor. I think that it says if they find this, then he is committed. The alternative is he's not committed. It's an if-then sort of proposition. And you know, this might be a kind of situation like the McLeod case, where this court found that an individual who's not serving a sentence for a sex offense was not eligible for civil commitment. In that case, the old Section 12 said it had to, the individual had to be serving a sentence for a sex offense. He wasn't in McLeod, and the court said, we're not going to imply this means anything other than what it says. The court said, we're not going to add language here. This is supposed to be strictly construed because it implicates fundamental liberty. And as a result, we're going to leave this to the legislature. If they want to fix this, then they can fix it. And what ultimately happened in that case was that the statute was amended and it was changed so that anybody who had ever committed been convicted of a sex offense in the past was. That's what this is all about. This is a situation here where the language is plain and It's just this court's job, particularly in light of the liberty interest involved, to interpret it as strictly as it's written.
But the plain language of the statute, and correct me if I'm wrong, also says that people shall be detained, right?
Of which provision, Your Honor?
Petitioner shall be detained, right?
If after a trial, a jury finds the defendant to be,
No, pending trial,
After probable cause.
after probable cause.
that's true.
Right.
But this court has said in Pariseau that,
Right, I understand that, but you,
and I acknowledge that there's some conflict between that and Knapp. You know, there is some,
Well,
however,
I
think.
believe it says the trial shall be, I mean, it refers to the trial, shall be,
A single trial, yes, correct.
so the question, I mean, I don't think, the fact of the matter is, I don't think the legislature anticipated what would happen with regard to a hung jury, so.
Well, the last thing I would say, Your Honor, is in the event that something is ambiguous, the answer has to be resolved in the favor of the defendant. That's what this court said in the Samuel S. case in terms of a rule of lenity. If there's doubt as to the intent of the legislature, the tie goes to the defendant here because he's the one who's been locked up for nearly 7 years awaiting a disposition in this case.
But don't you think when you have a statute that's talking about a trial, that there's some room for common law and for an understanding that if there's a mistrial, unless the government has goaded the defendant into a mistrial, that there can be another trial? Isn't that just so basic?
I think that this is not a criminal case and it's not a civil case. This is a creation of the statute. This civil commitment proceeding is driven by the language of the statute, and that's what guides us. And in the absence of some clear indication otherwise, this is the way you have to look at it. That's what I would submit.
But they're not dropping the statute into a vacuum. They're dropping the statute into a common law that goes back.
Well, I think this court would refer to common law principles in the absence of any direction from the statute. And I would submit that where the statute is plainly stated here, then that's where this court should go with it.
Okay, thank you.
Thank you.
Mr. Zanini, good morning.
Good morning. May it please the court. Jackson Eni for the Commonwealth. First, I need to correct typographical error on page 8 of the Commonwealth's brief, which is in the statement of the facts in the case that dates. The first sentence of page 8 refers to 2014, and it should refer to 2011. That's when the first counsel for the respondent was discharged, and new counsel was brought in after that. So I just want to correct those dates.
So why doesn't the rule of lenity apply here?
The rule of lenity only applies if the statute is ambiguous, and the statute is not ambiguous. So the statute, as Justice Lowy said, is written with the backdrop of the common law of trials and trial processes. If the legislature is silent as to the repeal of the common law, then the common law applies and controls in the trial. The Cabral case, which is 443 Mass at page 176, 443 Mass at 176, Cabral says, the statute is not to be interpreted as affecting a material change or a repeal of the common law unless the intent to do so is clearly expressed. There are no words in this statute clearly expressing any intent to repeal the common law. In order to repeal the common law, you would have to expressly say it. And you can't add language here where it's, at best, it's silent. But that silence is really just an acknowledgement and an adoption that a verdict, a trial is ended by a verdict.
But this isn't a criminal case, right?
No, but it's the same with all civil cases. If juries don't reach verdicts in civil cases, you have another trial. You don't just tell the parties, the case is now over, go home, we're dismissing the case.
is there a supervised release option?
Yeah, so Pariseau, I think, is barely touched on in the respondent's brief or the Commonwealth's brief, and the source of authority for the court to do supervised release was not clearly articulated in Pariseau, so I would be very cautious about that. I would also suggest that if you're going to examine supervised release, it of course relates to the other issues in this case, the due process issues, which is how much responsibility does the respondent bear for the delays in this case? Because in Pariseau, we're post-verdict, I guess we're sort of hanging, waiting for the verdict from the judge, but the trial's over, it's concluded, there's been a full, fair trial, and so if the judge delays too long, the respondent can seek release. But even then, the judge has to consider and weigh the danger to the public against the liberty interest. The danger to the public from this individual is extremely high, incredibly high. I've never actually
Not
seen.
so high, not so high that you 3 times could not get a unanimous jury to agree with you.
But when you have, as Louisiana v. Johnson, I think it is, says, just because you have a couple of completely unreasonable jurors
Do
who
we know
don't
that?
go along with
How
the
do
majority.
we know that? How do we know it was not 11 jurors?
We don't. But if you have 1 or 2
I understand that.
jurors.
I understand that. Well, that goes to my next
Commonwealth
question.
has met its burden of proof.
Well,
And I
mean,
think this
but-
goes
but the
to,
judge would not be obligated to grant supervised release. The judge would have the option.
yes.
And the judge would
yes.
then have to make that determination.
I agree under Pariseau.
Now,
And so there's-
arguably, had the judge believed that there was insufficient evidence for you to meet your burden, a directed verdict would have resulted, isn't that correct?
Yes, there were multiple motions for directed verdict, all of which have been denied. So we're clearly beyond probable cause, which the respondent stipulated to. We are beyond the 2 QE reports opining that he's SDP. We're beyond the directed verdict stage. We have more than sufficient evidence to get to the jury and prove beyond a reasonable doubt. And I think the lack of cooperation should be something that the jury actually gets an instruction on. So under the Poissant case from this court, the Commonwealth specifically sought their own SDP expert, and the court said, no, the defendant, the respondent, does not have to submit to a Commonwealth's QE because the statutory scheme requires him to submit to 2 QEs that the government has, and the Commonwealth gets 2 if their opinion is he's QE, he's SDP to proceed. This defendant
Okay,
refused.
but that's not before us. That's not within the scope of this appeal. I mean, the judge has not asked us to report on that question, has he?
No, but when you have such a broad issue here and such a broad scope, I'm just asking you to think about what is the likely reason why so far the jury's
You're asking us to
having
speculate, and
trouble.
we can't speculate as to that.
Well, we know because the juror wrote a note,
One
so
juror,
we're pretty clear.
one juror in one of the 3 trials. I mean, come on, that's, let me ask you another question.
Sure.
We have an unusual structure here. If a person is found unanimously by a jury to be sexually dangerous and is committed, and then under Section 9, after having been found sexually dangerous, seeks to revisit that, has a Section 9 trial, and 10 of the 12 jurors say he's not sexually dangerous, he is released, correct?
Yes.
Why should it be that if a jury is hung where the person has never been found unanimously by a jury to be sexually dangerous, that we do not import the same civil rule that if 10 of the 12 jurors say he's not sexually dangerous, that would bar a retrial?
Because the statute is clear in Section 14 that it's a unanimous verdict that's required.
We're certainly
And-
required to find him SDP, but it is silent as to the issue of what is to happen if the jury is hung.
Right, and that silence is not a repeal of the common law, and the common law is that you have a mistrial and you have another trial. And where the legislature
Under
chose...
the common law with regard to civil matters, 5 of 6 is sufficient. This is a civil commitment, is it not?
That's not the common law, that's by statute.
Okay, and
And
why should we not, as a matter of due process, interpret Section 14 to apply to have the same protection against a retrial and the extension of commitment as is provided for somebody who already has been found to be sexually dangerous? It's a rather
Because that's
unusual
not an-
circumstance.
That's not an interpretation, that's a rewriting of the statute
Well, I mean,
and
don't we,
adding
but,
language
but,
to
but
the
what does the
statute.
statute say about, show me where Section 14 speaks about a hung jury.
Because it's silent, the common law applies. The common law was not repealed. That's the Cabral case. The common law was not repealed. There's no express intent to repeal the common law. So if this court were to do that, in this case, you would be rewriting the statute.
Are there asymmetrical verdicts in the common law?
Not that I'm aware of. I think what's good for the goose is good for the gander under the common law. That's a well-known common law rule. So
Is there a rational basis for that distinction?
for asymmetrical
Yes.
verdicts.
Is there a rational basis for why a person who has already been found to be sexually dangerous is released when 5 of 6 jurors say he's not, but a person who has never been found to be sexually dangerous is not released?
Right, so I have two answers to that. One, it's irrelevant. It's up to the legislature to write the laws, and unless you say that this law is irrational, which you would have to strike down the law,
Now, what if we,
that's irrelevant.
what if we found that it would, that the provision would be in conflict with due process if we were not to save it by imposing the 5-6?
Well, under NAP and other cases, you've already said that the statute is compliant with procedural due process and substantive due process.
Where
So
have we spoken of it with respect to a hung jury in a mistrial?
You haven't addressed that yet.
Okay, so
But
that's
you're
my...
basically already said the statute is constitutional, complies with due process in every form. The other answer I have is that when you have a 10-12 verdict versus a unanimous verdict, similar to having different burdens of proof, what you're creating is, or balancing the likelihood of erroneous acquittals, for lack of a better word, versus likely, guilty verdicts. And so the legislature chose to balance it in a way where after the person has received treatment at the treatment center for a period of time, the balance in favor of an erroneous acquittal is a little bit more palatable to the legislature. Before there's any treatment, that balance does not weigh that way in the eyes of the legislature. And this is an individual who has refused to participate in treatment. And after Judge Wilkins, as part of his balancing and due process analysis, said to the DOC or the Commonwealth, you must offer him treatment if we're going to not put him on the street, or if we're going to continue on with this process. The DOC initially intervened and objected, but then agreed to offer treatment. He was offered treatment, and a month later, he declined and refused to participate. And when he declined, he said, I know how to get treatment, I know how to get in touch with staff, I know how to participate if I want to, I refuse. And he said that he was doing that after talking to his lawyer.
And if he is found SDP and refuses treatment, and if the jury...
And that in section,
If the jury finds under 5-6, you're saying it's a different result?
that's correct, but that's the legislature's balancing. So, and
But
the
he- but-
likelihood
but He can
that
refuse treatment even when he's committed, can he not?
he can, yes. But
Can-
again, that's a legislative judgment.
Counsel, one of the things that strikes me about this is that part of the problem here is the intertwining of the long time that has passed plus the mistrials. If you separate those two concepts and just look at multiple mistrials and take away the time element, how does that affect the balancing of the interests for due process concerns?
Yeah, there may be an outer limit at which multiple mistrials becomes a bar that you can't get past for due process reasons, but we're not at the outer limit. And there's a case that, there's no case in Massachusetts on point, and this case is not in the brief. U.S. v. Jones is 122 Fed 3rd 1058. 122 F 3rd 1058. It's the Second Circuit. As far as I know, it's unpublished. Cert was denied at 522 U.S. 976. Mr. Jones brought a due process claim to try to bar his fourth retrial. The Second Circuit rejected it. Mr. Jones conceded that there was no double jeopardy issue with his fourth retrial. And a good case on the double jeopardy and the number of retrials, State v. Ione from Connecticut, AILLON, 182 Connecticut 124, cites numerous cases where there have been 5 or 4 or 3 retrials without a double jeopardy issue. So I think the number of mistrials is not the issue. If we were in a more compressed time frame, it wouldn't be a concern. The time frame, again, now we have to look a little bit at constitutional due process concerns on the time frame. So if you think about the outer limits of speedy trial and due process under the Sixth Amendment, I would suggest that some of the cases from this court have addressed 4-year delays, 7-year delays. The U.S. Supreme Court has looked at equally long delays.
Do you agree that that's how we should look at it as far as the due process and the timeframe, that Parker v. Wingo and the 4 factors is the way to analyze this?
I think that's probably right because of the liberty interest at stake and because you have to, at some point, there's an outer limit.
Would the
on
possibility
liberty interest.
of release under Perazo then kick in?
I think the possibility of release actually resolves the concern. If the judge can weigh the liberty interest and the other competing interests, then that addresses the due process concern, and then that lays the issue to rest. You never get to dismissal as long as the judge has the authority to engage in the proper balancing of the government interest, the private interest, and the social costs.
And that happens after the first trial?
That could potentially happen as early as after at the first mistrial. The defendant could seek release as early as that, and the judge would engage in the balancing test.
If we were to impose, though, the Sixth Amendment speedy trial analysis doctrine onto this situation, release would not be dispositive of that 4-pronged test.
No, that's correct. But since this is a civil proceeding, the Sixth Amendment really is inapplicable.
We're just looking for something to see, to try and analyze the due process issues at some point in time, some amount of mistrials. There's a point in time in which, we could debate what it is, but there's a point in time in which you're talking about a due process issue. Whether it's here now or not is the question.
Well, potentially, unless in fact release solves the due process liberty interest problem. I think the release solves the due process liberty interest problem. If the availability of release or the potential for release solves the liberty interest, resolves that issue, then there is no dismissal. So the Sixth Amendment sort of speedy trial analysis is really inapt and doesn't apply. If it does apply, you get into all of the respondents' calculated delays in this case, which have brought us down the road many years. That's how we got here, is by the respondents' calculated delays.
Now, if you set those aside, how many years do we have? We have 7 years since he's been held, I believe. I think it was January of 2010.
Right. So
put aside all of the delay you consider to be caused by the petitioner. How many years do we still have left?
So how much delay was caused directly by the Commonwealth seeking delay? There was one.
Or by the fact that there were new trials. So, I mean, I don't blame the Commonwealth for, I don't blame the Commonwealth really for, it's not a matter of blaming the Commonwealth, but it takes a while to do 3 trials. So I'm asking you, put aside all of the delay which you consider to be the fault of the petitioner. If you set aside all that time as essentially excludable, how much delay do we have here?
Very little. There was a 2-week delay at one point when an ADA had to go to Florida to visit her ailing father. And then there are only the delays for just rescheduling the trials, many of which he agreed to. The first 2 years, by the way, were time wait. The defendant asked for funds for QEs. He got funds for QEs. He had 2 SDP reports done. If you look at page 10, footnote 10 of the Commonwealth's brief, those SDP reports were not completed until September and November of 2012. So the first 2 years of delay, right off the bat, are the respondents' QE delays. The last year plus of delay is due to the appellate process, which is a relatively quick appeal, frankly. So there's 3 years that we're all set with. There are citations in the brief and pleadings in the brief and pleadings in the appendix where the defendant was specifically filing either the respondent himself signed a waiver or his lawyer signed a waiver of any potential speedy trial claim. There were a lot of, unfortunately, Attorney Harrington had several medical issues. There was much delay due to the respondent choosing to continue on with this counsel, unlike the first lawyer who he fired. He wanted this lawyer, and he was willing to wait. So almost all of the delay in this case is directly due to the respondent, his choices, his conduct. Whatever due process rights he has, he can waive, and he can waive it by his conduct, and that's what he did here. Unless the court has further questions, I will rest on the brief.
All right, thank you.
Thank you.